My name is Chantelle Hosseiny, and I'm joined here by Carl Ulrich and Professor Eric Adams from the University of Alberta. We're here on behalf of the Edmonton chapter of Dine with Dignity. No, it's not letting me. Just 1 second here, sorry. So Dine with Dignity Canada is a national human rights charity, and we're committed to improving quality of dying, protecting end-of-life rights, and helping Canadians avoid unwanted suffering. We're here to represent the 86% of Canadians who support the Supreme Court's right of decision to allow medical assistance in dying. Our mission is to ensure that Canadians have access to quality end-of-life choice and care, and we do this through advocacy, public education, and personal support. There are chapters across Canada. We're here for the Edmonton chapter. There's a Calgary one, or if you're interested and are not part of a chapter, just check out the website, and there's a lot of information about where you can get involved if you're interested in that. If you or someone you love is seeking medical assistance in dying or information about palliative care, it can be accessed through this Alberta Health Services website. You can just call 811 also, that's another option, or there's a direct email at the bottom there, maid.careteam@ahs.ca. So if you or anyone you know needs more information, they're very helpful, and there is a navigator that will help you through the process. Before I introduce our guests, I'd just like to acknowledge that we are on Treaty 6 territory, traditional meeting ground, gathering place, and traveling route to the Cree, Saulteaux, Blackfoot, Métis, Dene, Nakota Sioux people, and we acknowledge all the many First Nations, Métis, and Inuit whose footsteps have marked these lands for centuries. Without further ado, it's Professor Eric Adams joining us tonight. He's the Vice Dean and Professor at the University of Alberta Faculty of Law. He's well known for many publications, including those in the fields of constitutional law and human rights. I first became aware of Professor Adams when I read one of his articles in the Globe and Mail titled, "How Do We Balance Rights in Cases of Medical Assisted Dying?" And that was written in regards to an incident that occurred outside a faith-based Edmonton hospital in October of 2017. But we are lucky enough to get him here the day after Bill C-7 was passed, which is very exciting. And oh my goodness, sorry, as I disappear. And more recently, he provided extra testimony at the Legal and Constitutional Affairs Committee of the Senate of Canada, and he's here to share his perspectives with us. So welcome, Professor Adams. Before you begin, I'd just like to, if anyone has questions and answers, just please enter them in the question and answer as opposed to the chat portion of this webinar. Thank you.
Oh, thanks so much, Chantelle, and good evening to everybody from wherever you may be listening in from. You are allowed to update me if the Oilers are beating the Jets. If they're behind, I don't want to know about it. So that's one of the ground rules for this evening. I taught for a couple of hours today already, and so pardon my voice, but I can assure you I'm thrilled to be here to talk about this incredibly important topic. And as Chantelle said, what an auspicious moment to be talking about it because of the really historic decision in the Parliament of Canada yesterday. So maybe I'll just give you a sketch of how I'm going to outline my remarks for the time that I have. I'll speak for about 20 minutes or so, and I'm really interested in the legal background to how we got here. So I will tell a bit of that story. It's going to be familiar to some of you, but maybe not all of the details to others. I will address a bit of the constitutional issues that I see that remain and are part, I think, of the landscape going forward. And then I'll be really pleased to think through and answer any questions that come up in the Q&A. Let me just say at the outset that I'm a constitutional scholar and lawyer. I come at this from the perspective of constitutional law. I'm interested in the ways in which the Constitution interacts with the medical assistance in dying regime. I'm interested in the rights discourse and the rights of Canadians that come up in this very contentious area of public policy. I am not a physician, and I am not a medical ethicist, and my family of physicians would really like me to have it on the record that I have no medical training. However, that said, I've been interested in this issue for a very long time, and was really delighted to be in consultation with a number of senators in advance of the Senate's debate of this particular bill. And on the basis of a number of those conversations, I was pleased to give testimony in the expert hearings leading to the passage of Bill C-7. I will say also that for a long time this has been an academic interest, but I also, like so many of us, of course, it's hard to get through life without a personal connection to this story. And last year we lost my mom, and unfortunately it was under a MAID regime that was not able to assist her. So she unfortunately passed in a world in which advanced directives were not available to ease her suffering at the end of her life. And even though she wanted MAID and wanted a peaceful end, it was a cruel, in my view, legal regime that denied her and those that loved her the peace of that exit. And so I have that personal connection to this story as well. So let me say that as a lawyer and legal historian, it's perhaps not a surprise to know that as long as there has been life, there have been laws about death, whether they were religious or secular. We have always, in this most profound moment of passage from this life, had ritual and law that governed that process. That is just something inherent in human life. And so the laws that have governed our death have long also governed both suicide and individuals seeking assistance in suicide. So the medieval common law of England found that suicide was a crime against both God and the king. And there were physical penalties visited upon the body for those that may attempt suicide. When Canada becomes a country, it adopts the English common law as the foundation of Canadian public law. Not only English public law, there's also, of course, French law and there's Indigenous law, but in that mix of the legal traditions, the English common law says that both suicide and any attempts to assist or abet a suicide are crimes. And so that was the law of Canada, and it remained the law of Canada when in 1892, Canada first enacted the codification of its criminal laws. That is, take all of the common law crimes that were in existence through judge-made law and turn it into the Canadian Criminal Code, which occurred again at the end of the 19th century. And in that very first codification of the Canadian criminal law were crimes of both suicide and attempts to aid or abet a suicide. In 1972, Canada, thankfully, the Parliament of Canada removed the crime of attempting suicide from the Canadian Criminal Code. But left intact was Section 241 of the Criminal Code, which remained a criminal offense to aid or abet a suicide. And that remains the law today, but for an exception, which entered into the law first after the Carter decision, which I'll talk about in a moment. So the legal landscape in Canada for virtually all of our history as a country has been the criminalization of medical assistance in dying. We have a much longer history of criminalizing that behavior than of legalizing it. And everybody in this room is going to know that Sue Rodriguez was the first to challenge the constitutionality of that provision of the criminal code, which she did in 1993. That case was decided by a divided Supreme Court of Canada. I have spoken with judges on the Supreme Court of Canada from that period who say that was the hardest case they ever heard. And that remark came from a judge who upheld the legality of the prohibition on medical assistance in dying. Sue Rodriguez loses her case, as you know. Here's what the Supreme Court of Canada said in Rodriguez in 1993. This is from the judgment of Justice Sopinka. He said, sanctity of life has been understood historically as excluding freedom of choice in the self-infliction of death, and certainly in the involvement of others in carrying out that choice. And that was probably true as a descriptive statement that historically Canada had always criminalized that behavior. But on the basis of that history, Justice Sopinka and the others in the majority of Rodriguez said that meant that there could be no principle of fundamental justice in the Charter of Rights and Freedoms that would authorize somebody the autonomy of a choice of medical assistance in dying. The court argued that there simply was no social consensus on that topic that would make medical assistance in dying a constitutional requirement under the Charter. Everyone here is going to also know that in 2015, in a quite a famous reversal of the Supreme Court of Canada's decision in 1993, a now unanimous Supreme Court of Canada upheld the trial decision in Carter and Canada. The really brave and remarkable trial decision of Justice Lynn Smith. And if you ever have a weekend and you would like to print off a 800 paragraph decision, try the trial decision in Carter and Canada, not the Supreme Court of Canada decision, in which you see the painstaking work of Justice Lynn Smith, now retired, as she works through an incredible mountain of evidence from incredible lawyers and advocates and very brave plaintiffs to make the case that this issue should not be settled for all time, but should be revisited under new arguments under both Section 15, the equality rights, and Section 7. An incredibly talented lawyer who argued that case, Joseph Arve, or one of the lawyers in that case, sadly passed away earlier this year. And some of you will know the memory and the tenacious advocacy of Joe Arve on this file. So what did the Supreme Court decide in Carter and Canada? Well, the Supreme Court decided that Justice Lynn Smith was right, and that both Section 7 and 15 were offended and infringed by the prohibition, the total prohibition on medical assistance in dying in the criminal code, the criminalization of medical assistance in dying. Here's what the court said. Again, I think deliberately, using the expression sanctity of life that I quoted a moment ago from Justice Sopinka. The court wrote, the sanctity of life is one of our most fundamental societal values. Section 7 of the Charter, which protects life, liberty, and security of the person, Section 7 is rooted in profound respect for the value of human life. But Section 7 also encompasses life, liberty, and security of the person during the passage to death. And that's a remarkable moment in the judgment, because it said that our lives also have meaning in the choices we may make around death and the dignity that has to surround that process and should surround that process in order to fully respect the rights and dignity of those who are suffering. So Parliament responded to the Carter decision. It took them a while to do so. The court gave them a 12-month deadline. And like good university students everywhere, they knew that sometimes you need to extend a deadline. So they pressed the court on a number of occasions to extend that deadline, which the court did. And it was then in June, I believe, of 2016 that a new MAID regime was legalized in Canada with amendments to the criminal code. So the criminal prohibition on abetting and aiding suicide remains, and it does today in the criminal code. But what the new amendments created was an exception for MAID. And that exception said that MAID could be provided of course that it was voluntary, and that some individual was suffering from a grievous and irremediable medical condition. The court went on to define what grievous and irremediable condition meant. And among those characteristics, the legislation defined grievous and irremediable as including someone whose death has become reasonably foreseeable. Now, what exactly did that mean? It was left for judges and medical practitioners to define, but some proximity to death became part of the necessary characteristics of some individual that was able to seek MAID. In other words, someone who was suffering from an incurable medical condition, who may otherwise qualify and who may wish and seek medical assistance in dying, would not be able to do so because of their distance to a natural death. That meant in some cases that individuals would be subjected to perhaps decades of suffering as a result of the restriction. That restriction was constitutionally challenged in Quebec court, a case that became known as the Truchon decision. And in Truchon, the restriction to reasonable foreseeability of death was struck down as an interference in both equality rights and Section 7, life, liberty, and security of the person. Why? Because the court held individuals in Canada are being treated differently based on their type of medical condition. Some individuals with some kinds of medical conditions who are suffering will qualify for MAID, but other individuals, based solely on their type of medical condition and their proximity to death, will be denied those same dignified choices. Here's what Justice Baudouin said in Truchon. She said, a legislative regime within which suffering takes a back seat to the temporal connection with death is what Canada has. And so she struck down the requirement, as I said, and again gave Parliament time to amend the legislation to comply with this, this constitutional ruling that said that individuals could not be distinguished in terms of their proximity to death when what they were seeking was a dignified exercise of their rights to end suffering. This has been a long process to come to Bill C-7, and perhaps the process is ongoing because there is a parliamentary review built into C-7, and a number of individuals have indicated that it may be that this MAID regime continues to need refinement in the years ahead. And I think, as I'll mention in a few moments, there are opponents to the expansion of the MAID regime who may seek to bring their own constitutional challenges to its new terms. So let me say a little bit then about this new regime. essentially, there are a number of parts to these amendments, but in removing the requirement of reasonable foreseeability of death, the new regime, now the law of Canada, sets up really two routes to access MAID. It still distinguishes individuals based on their proximity to death. So those with grievous and irremediable medical conditions who are suffering, who qualify for MAID and whose death is reasonably foreseeable. Let's think of late stage cancer patients, for one example. They will have one set of processes under the Act that effectively remains static from the old regime with some minor alterations. But a new pathway is created, a new pathway with some additional protections in terms of the process to ensure that decisions are truly voluntary for those whose death is not reasonably foreseeable. A slightly different set of preconditions, but ultimately the same destination of medical assistance in dying, even if death is not reasonably foreseeable. And I see this as a major development in the law and a very positive development in the law, provided that the safeguards, and I think it's important that there are safeguards, that those safeguards are in place, which I believe they are and will continue to be. The new MAID regime also allowed some limited expansion of advanced directives, that is, advanced directives for those whose death is reasonably foreseeable. And this is the regime that would have assisted my mom. And so I'm very glad to see it in place. I wonder if this is the end of the story on advanced directives. And there is still no ability to access advanced directives for a broader category of individuals, for individuals whose death is not reasonably foreseeable. Parliament at the moment continues to want to deal with these communities in a different way, one from the other. And there are arguments for and against that difference of treatment. We'll see if that policy changes in the future. One of the possible amendments that came from the Senate was an expansion of the advanced directives regime, and that was not accepted by the House of Commons, and so it's not part of the law. The other interesting development in the regime was the explicit exclusion of individuals who suffered from a sole mental illness as part of their medical condition. So there were a couple of exceptions to the exception. So the expansion of access to MAID also had limiting provisions. Individuals could not, for example, had to be over 18. So minors and mature minors continue to be not able to access the MAID regime. But the other exclusion was that individuals whose sole underlying medical condition related to a mental illness, those individuals who did not have a physically derived medical condition, but rather a mental one, but who otherwise would qualify. Again, remember, there are other characteristics that have to be met in order to qualify for MAID. It has to be a grievous and irremediable medical condition that causes intolerable suffering. Those individuals under the new regime would be excluded with a total exclusion. I argued that exclusion when I appeared before the Senate subcommittee on constitutional affairs, that exclusion was very likely to come under constitutional challenge, and that it may well have been struck down in future litigation as, again, making a distinction that I do not think can be ultimately sustained in the regime. Why? Because individuals are being treated differently, not because of their own suffering, but because of the particular origin of their medical suffering. And that means that a distinction is being made on the basis of mental disability captured by Section 15 of the Charter. And there's no question that that's a distinction in the law that would then have to be defended by the government as not discrimination. Why do I think that that may be suspect to constitutional challenge? Well, because for the same reasons that the total prohibition on medical assistance in dying was struck down in Carter, and for the same reason that the total prohibition on medical assistance in dying for those whose death was not reasonably foreseeable was struck down in Truchon, in both of those cases, the court said, but there are non-vulnerable people who wish to exercise their rights to dignified medical assistance in dying who are being prevented from doing so by a total prohibition. So separate the vulnerable from the non-vulnerable. It does not make sense to have a regime which totally excludes individuals if you can devise a system to distinguish the vulnerable from the non-vulnerable. There are arguments that it is more difficult to distinguish the vulnerable from the non-vulnerable, those who are truly exercising a voluntary capacity from those who are not, when the condition is related to a mental illness. And I believe that that's likely true, that poses a more difficult challenge. But I suppose the question is, does it impose a challenge that cannot be overcome by appropriate medical safeguards, by appropriate counseling, by appropriate time delays, so that you know an individual is not choosing death because of suicidal ideation. They're not choosing death in a moment of depression. They're not choosing death in a moment of weakness, but they are actually coming to this decision deliberately, voluntarily, and seeking to exercise their full rights as would anyone else. And I'm of the view that such a system is very likely divisible if it's carefully done, for the same reasons that such a system was divisible to determine people who should access MAID should have the opportunity to access MAID in the first place. Alberta has a case on the books exactly of this nature. After the Carter case struck down the restrictions on MAID, there was a period before the new law came into effect in which individuals could access MAID by applying to a court to be granted access to MAID before the new regime came into effect. And this is in the year 2015, 2016. And someone by the name of AF in Alberta, whose sole underlying medical condition was a mental illness, but who was suffering tremendously and was otherwise a fully voluntary or exercising a full voluntary decision to end her suffering. The Alberta Court of Appeal granted that access to MAID on the basis that the individual was not being coerced into death, that individual was not vulnerable, that individual was making fully informed decisions, as was her right to do so. And again, I think if we know that there are individuals who will share in AF's conditions and share in AF's suffering, then I'm interested in a regime that would provide the same opportunities to respect those individuals' rights of choice. So interesting moment in the history of legislation was that it was the Senate of Canada who pushed the Parliament of Canada to address the exclusion of of those whose medical condition is a mental illness. And as a result of Senate amendments, which have now been accepted by the House of Commons and are now the law, the exclusion still stands, but will the sun will set on that exclusion in 2 years' time. And the idea is that in that period, Parliament would work on devising the system that should be in place to protect the full rights of individual whose condition is a sole underlying mental illness. So that is a bit to be determined. Because we know that the sun will set on that exclusion, I think it unlikely that we have constitutional litigation on that particular question. I think everyone will focus their energies on addressing through the legislative process that particular exclusion. So that's a future issue. The other, and I think it's really the reason why that I was asked to speak here tonight was ongoing issues that will continue in relation to access of MAID, especially in care facilities with an affiliation with Covenant Health and Catholic organizations generally. Alberta is somewhat unique, but not totally unique in having a longstanding history of Catholic institutions providing healthcare, and providing healthcare through teachings that speak directly to the Catholic faith. And that's part of the mission and part of the provision of care in some hospitals, and in particular in long-term care facilities. Well, you probably remember the story that generated the op-ed that I wrote with a colleague of mine, Ubaka Ogbogu, in the Globe and Mail in I think it maybe is 2018, in which news, because of some really incredible reporting by CBC, news came to light that an individual, Doreen Nowicki, had received, who was in long-term care in a Covenant Health facility, had requested a medical assistance in dying. She qualified for medical assistance in dying given her circumstance. And because her facility was not willing to provide even the assessment of whether she qualified or not, that what came to light is that there was a widespread practice of moving individuals to other facilities. And in the case of Ms. Nowicki, was moved to the sidewalk outside of the facility where the assessment process began. Ms. Nowicki found that an upsetting experience. Who wouldn't? And canceled the assessment, and it was only later at a separate and different facility received medical assistance in dying. That episode really opened the, I think, conversation for many of us about some of the tensions at the heart of this question. How do we address institutions in Edmonton, in Alberta, which are professing to be morally opposed to the practice of medical assistance in dying, when some individuals, not by their own choice, but because those are the available beds, will find themselves in those institutions? And in my opinion editorial, I argued, perhaps naively, that I want to live in a world that respects the important role and history of Catholic participation in the healthcare system. I think there are reasons, when we live in a society committed to rights and freedoms, to understand that both individuals and sometimes institutions will be diverse in their views. And I think, although I will say I am not a Catholic, I would like to live in a world in which Catholics and their institutions enjoy full protection of their constitutional rights to their faith and their beliefs. For me, that's critical. how do we square these tensions? In the piece that I wrote, I talked a little bit about an interesting case out of Quebec in which the Supreme Court of Canada dealt with Catholic education. And what happened in Quebec, and of course, Catholic education has a long and important history in the Quebec schooling system, as it does in a number of provinces with institutionalized, publicly funded Catholic education. Alberta and Ontario are other examples. And in the Quebec Loyola case, the government of Quebec ordered Catholic schools through the regulations under their control of provincial education. The government of Quebec said, here's the ways in which you have to teach your Catholic religion class. You have to do this, you have to do this, you have to make sure you do this, you have to do that. And then the government of Quebec outlined that Catholic schools must also have world religion cases and expose their students to diverse religious teachings, teach students about diverse religious practices and the diversity of religious views in the world in which they would encounter. The school challenged both of those regulations as unconstitutional infringements of freedom of religion. And the first part of that judgment that's important is that the court recognizes that groups of individuals that gather together can express religious freedoms. So it's not simply an individual right, that collections of Catholic parents and schools could and importantly should have religious rights. And that meant that if the government of Quebec was going to tell that Catholic institution how it had to teach about Catholicism, it was infringing the rights of those Catholic institutions and the Catholic parents and the Catholic students that went there. You cannot dictate and shouldn't be able to dictate to a religious group their own conception of their faith. And I think that's right. There was not a justified reason to infringe with a Catholic school teaching Catholicism according to the ways in which the Catholic institution wanted to teach it. But remember that there were two aspects of the law that were challenged. The second aspect that the Catholic school challenged was the government's directive to teach about other religions in the world. And there the government said, no, that's not an infringement of your religious freedoms. It's a reality of an education system that has to prepare students to live in a diverse and plural world. It's a reality of an education system in which some students may not be Catholic. And so is an interference with Catholicism for a government to insist that a Catholic institution also recognize the rights and freedoms of others and the rights and freedoms that are part of the fabric of a diverse world? And that answer seems to me to be absolutely correct. How do we translate that into Catholic healthcare? Well, I don't think that Covenant Health should be asked to remove the aspects of Catholicism which form the heart of the institution. There are going to be crosses and Bible quotes on the walls of some Covenant Health facilities. There's going to be an integration of some faith leaders into those facilities. I don't have a problem with that. But I do think, just as a Catholic school has to teach about the diverse religions of the world, a Catholic healthcare institution has to exist in a world that provides legal healthcare to individuals who may or may not be Catholic, who may or may not be in the institution under their own set of choices and have to be offered and protected in the exercise of their full rights to full medical care, which includes MAID. I think an example is well captured by the effective policy referral decision of the Ontario College of Physicians and Surgeons. So the Ontario College of Physicians and Surgeons says, just as the legislation of MAID provides, individual physicians and care providers should not be compelled to provide a medical service that goes against their deeply held religious convictions. But, says the Ontario College of Physicians and Surgeons, medical providers must provide effective referrals to individuals who will. And effective referrals means you provide information and you provide a pathway and you provide a connection to where that medical right can be exercised. A number of physicians challenged that policy as interfering with their religious freedoms, and the Ontario Court of Appeal said it was a minor interference in religious freedom to effectively refer somebody to medical care, which your religious beliefs opposed, but it was a justified infringement under Section 1 of the Charter, which allows for the rights and freedoms to be limited in accordance with the principles of a free and democratic society. So again, for me, the case law is moving in the direction of protecting or attempting, I think, the difficult but not impossible balance of protecting individual rights and liberties on the one hand and ensuring that individuals have effective access to the medical care to which they are entitled. And that may create some tensions for some individuals in the healthcare field. It may create some tensions in some institutions which are devoted to Catholic teaching, but those are tensions that have to be, in my view, resolved. And I think they can be resolved in favor of a balanced approach that protects both. So why don't I leave my remarks there? I'm happy to hear what questions any of this may have raised for people and to take a moment to stop talking. I'll thank you for your interest and really appreciate your time and the invitation to be here.
Thank you so much. That was really informative. I really appreciated the history of how that all came to be where it is today. We do have a lot of questions coming in about just Catholic, the publicly funded institutions, right? So how do we balance these rights, the right to informed consent, the right to patient autonomy, with the right of an institution? When are we going to put these institutional rights, like human rights, how do we balance this, and what needs to be done to make sure that individual rights are being honored in these institutions?
Yeah, it's a great question, and I think that is one way is to keep the conversation. If the practices of unequal access are not happening out in the open, and if they're happening quietly, and if there's not full transparency about the difficulties that individuals are experiencing and accessing different kinds of care, then I think we have trouble continuing this conversation. So step one is, the participants in the healthcare system need to keep having this conversation. Those are seeking the care need to keep having the conversation about access. Those that are working in the system need to keep having the conversation about access. And to a certain extent, if this is a political issue, and it should be, those of us outside of the healthcare field should continue to make our politicians aware that this is a matter of importance to us. and that access to medical assistance in dying, like all kinds of compassionate care, are critical for Albertans, and they're going to be critical to receive in all of the places that Albertans are going to find themselves, including Catholic run facilities. The second part of that equation is the law. And so we know that sometimes politics and sometimes conversations and sometimes simply having the conversation does not advance the agenda. And so may there be constitutional challenges of unequal access? I think certainly that's possible. It's difficult to place that burden on individuals who are at the end of their lives and who are otherwise suffering. But it's certainly possible that we see litigation entering into this conversation, and the involvement of courts in trying to find that balance. We do not yet have a series of precedents from courts which will map out the precise balance for us to take. So we don't know, and I don't know, what is the precise way in which a court is going to resolve these issues if they arise. But my hope is that a court is able to use the existing approach to protecting charter rights that I think exists to find that path, which says that that Catholic institutions get to be Catholic institutions, and they've got to find a way to also provide medical care that is legal in this country.
I definitely agree with you that it would be lovely if patients were carrying these conversations on. Unfortunately, what we hear from people is by the time they are seeking medical assistance and dying, they're tired. They're literally at the end of their life, right? They just want to move on peacefully. So I do feel that we haven't been able to maybe move it forward as much as if it were some other procedure because of the stage in life that these people who are seeking this are in. Do you feel like this would be better overturned in the court or politically? And is it going to take an individual, or is there a class action? Is it just the public? Is it one person who's really hurt? How do you see the justice that we are seeking, or the access that we are seeking as an organization? What do you feel the best steps to get there would be?
It's a great question, and I wish I knew the best and truest path to walk to get there. And I don't think I have magic at my fingertips, but I do think that that in these kinds of moments, multi-strategies are probably the best bet for individuals that care about this, and for organizations that want to keep this on the political agenda. It's naive to think that the law might not play an important role in helping to advance this conversation. Certainly, these are the kinds of topics that traditionally politicians have been shy about running with. And I think it's understandable to know why that is, that these are deeply felt issues, which raise complex emotions and complex identities across the political spectrum. And something I didn't talk about, but I gestured to, is a powerful disabilities community that hasn't always been well listened to, who says, why is the answer medical assistance in dying to the crisis of suffering for persons with disabilities? Why isn't the answer better support, better housing, a society that was truly committed to their participation? And you know, I listen to and respect those views. I've worked in the disabilities community, and I know that those perspectives are very heartfelt and genuine and powerful. But I also think they don't need to be trade-offs. I think there's no reason why we can't be a society that's more committed to both compassion for individuals who may seek MAID, and a society that's much better equipped to support individuals who are facing suffering but want to live full participatory lives. And I guess when I come back to the question of the right strategy in terms of MAID access in Alberta today, I think I'm not in favor of simply saying, you know, let the courts make all these decisions. I think we as citizens and Albertans and politicians and interest groups have to be part of that, should be part of that conversation. But let's be honest, MAID is a topic that has moved because of litigation. It's moved because of the advocacy of lawyers and plaintiffs. I think that's true.
Eric, would a factor that one of the things that we're concerned about with Dying with Dignity is we've done a number of public surveys by Ipsos in both Alberta and across the country. And what we found is that it's 75 to 85% of people in our Canadian public who strongly support the right to MAID. And this is true among Catholics, it's true among the disabled community, it's true among conservatives. It's right across the board, so that the organizations that represent these people have a very different attitude than their membership. So how, you know, this seems like a contradiction, or anyway, the public is with us on this, but it's the leadership of these organizations that, in my opinion, simply are not representing their people.
It's a great question, Carl, and I'll just say this: any time in the long arc of legislative and constitutional change, you have the public solidly behind you. That's a better position to be in than not. So, you know, you may feel like we're moving too slow on this, but my sense is that when you look at other important moments of social change, think about same-sex marriage. It's a little bit like, what did Ernest Hemingway say about going bankrupt? First it went slow, then it went fast. It seems like you're on a long, slow road, but when the public is with you, then that social change can switch, and it can switch in a hurry. And it may be this moment where a strong consensus has not yet reflected itself fully in the policies, but that, you know, part of the parliamentary votes that we just saw on MAID were a reflection of the reality that you just talked about. The debates in Parliament were informed by a deep knowledge, I think, that this is an issue which Canadians have not uniform views, no question, but that there are some common perspectives that are important to bring to the fore. So I do think that's helpful, but whether it's going to move quickly enough without litigation, without a more determined political strategy, I don't have the answer to that. And I do know also that sometimes politicians are very attuned not to the 72%, but how loud the 16% is. How loud, how powerful, how connected, and how deeply that community feels about an issue. And so when politicians are dividing their calculus, they not only pay attention to how people feel, They pay attention to how deeply people feel. Is this a topic that moves a vote? And that becomes a slightly different calibration.
I know we're running a little bit short on time already. Are you okay sticking around for a few minutes to answer some of these questions? I feel like we haven't quite gotten to them yet. The one I wanted to start with is, where did it go? Oh, how will it be possible to convince advocacy groups for disabled and mentally ill people that most vulnerable of them will be protected?
Oh, it's a great question. And of course, the disability community, like all of our communities, is one of mixed views. I think that's fair to say. So I don't want to paint with a broad brush here. There are lots of diverse views within the disabled community, or the community that represents disabled persons with disabilities. But it's also just a fact that the advocacy groups representing persons with disabilities were powerful in their condemnation of MAID. They made an impact, and a powerful impact. And their concerns are about their lives. Some would say literally their lives are now rendered less meaningful, more at risk, and have been corroded by an expansion to MAID that I happen to think of as a positive development. And so that, there's a gap. How do we bridge that gap? Well, some of it will be in the proof is in the pudding. So, the medical community has to step up. Hospitals and care providers have to step up into the world that I think they're capable of fulfilling, which is providing care and ensuring that the distinction between vulnerable and non-vulnerable is real. That's, I think, absolutely critical. I have faith that was exactly what will occur, but I stress how important that is. And number two, that the community representing persons with disabilities is also listened to, because they're not only saying that they have a concern about MAID, but they're also saying that they have a concern about the quality of life that too many Canadians are living. And that's something we can do something about. That is something that we can connect to the cause of expanded access. We can make our voices also heard, that vulnerable peoples with disabilities need full access to living rich and participatory lives. And to the extent that those peoples remain vulnerable and marginalized, and the extent to which those communities are more vulnerable when they're racialized and when they're Indigenous, in my view, we would go a long way to listening to that concern and adding our voices to those that want to improve resources for that community.
I think it's safe to say that anyone in our organization or otherwise really would like to see both things happen. We would like to see, more supports, more access to the treatments that these people need to live a full enriched life. I feel like we do. It's not an and or thing, right? Yeah. All right, another question. We'll answer a few more. I know we're kind of running over already. I'm sorry, I lost myself here. Go ahead. Do you want to go ahead, Carl? Sorry.
Except Carl's on mute.
Oh, sorry. Do you envision a third round of new legislation coming in the near future to take account into some aspects of MAID that are still to be examined and legislated?
I do. I think that's where I would be comfortable predicting that we have not seen the final version of the MAID regime. I think there are enough both provisions in the existing law that are calling for further study, and then the sunset clause on the sole medical condition being a mental illness. And I think, frankly, the continuing conversation in the broader public, all of those factors, I think, mean that that this issue will continue to be dealt with through alterations. I hope we continue to be open to improving it. We don't always get things right when we legislate the first, the second, the third time round. And I hope we can respond to the evidence on the ground. Let's see what happens, and let's see where the problems in the system are, and let's correct those problems. I'm certainly open to that, and I think that and hope that the legislators remain open to that as well.
That's great. The other thing I'm seeing lots of questions and confusion about is the difference between advance directives and advance requests, and what this means in regards to the new legislation that was just passed.
I'll be a little bit cautious here because I'm not an expert, and so take everything I say with a grain of salt here. But the advance directives, as they were being understood and articulated in the Act, was really to capture a person who would qualify for MAID, but who may lose the ability to consent to MAID on the day of the procedure. The previous regime required consent on the day of the procedure. So both pre-qualification and then consent on the day of. That had a couple of unfortunate consequences, is that some individuals who would otherwise prefer to live for more days accessed MAID early because they were worried that they would lose the capacity to consent. And so it actually ended up shortening some lives, I think, in a way that was unfortunate and in some cases tragic. And then there was the case of those who wanted MAID, who had set up and qualified to receive MAID, and then who lacked the capacity on the particular day of. And those individuals and their families also suffered. So the new regime says that individuals whose death is reasonably foreseeable will be able to put in place an advanced directive, which will allow, if they qualify for MAID, for them to receive MAID on a date of that individual's choosing, even if that individual is not capable of consenting on the day because of a loss of capacity. And that's an important alteration of the law. Does it allow people who have set up an advanced directive now when they're otherwise healthy to be granted MAID? Well, that's the area of the law that I'm not, someone here knows the answer better than I do, but in my view that the MAID legislation is not set up to accommodate those requests.
You know, I think to clarify that, there's a difference between advanced consent, which is now possible, and an advanced directive is when I'm perfectly healthy, but I put in my personal directive that if certain things should happen in the long future, this is what I would like, and that is what is not allowed. So it's the difference between advanced consent and advanced directive.
That is exactly right, and I misspoke. Advanced consent was the term I was searching for. Carl, thank you for supplying it. So advanced consent is what the regime now allows. Exactly, thank you. Oh, Chantelle, I can't hear you because you're on mute.
So we're still, you can tell, really interested in pursuing change and increasing access for those that we are fighting for. And this one is another question, that what is the possibility of families that have been denied MAID to have a class action lawsuit with gathered stories, helping people take issues forward? We already know that there were hundreds of people who have had problems accessing MAID, and currently in Edmonton, forced transfers are a huge issue. So do you think that there's a possibility of this happening?
Well, I certainly think it's possible. Yes, absolutely. You know, I think that the court pays attention to the stories of the litigants at the hearts of these cases. There's no question that Gloria Taylor's story mattered in Carter. And that was also true of Truchon, and it was, of course, true of Sue Rodriguez. Courts look at evidence, and it's not just an idea that they want to hear about. They want to hear about the people at the heart of these issues who may or may not have suffered and whose rights are being denied. So
Audrey's amendment, we're really proud to see that go through.
Yeah. So if there are collections of people who can come together through a litigation effort, then you know, the past has suggested that can be really successful.
All right, thank you. What time is it here? Do we have time for one? We should probably wrap up, unless, Carl, do you have anything else to add before we get going, or any questions?
I'm a little bit worried that no one has mentioned the hockey game, which suggests that things are not going well for the Oilers.
I'm having a hard enough time between the chat and the cameras, so I have not had a chance to check on the hockey.
Okay, Lisa tells me I can relax. Okay, thank you, Lisa.
All right, well, oh, go ahead, Carl.
We did have one question here, and that was if you could clarify, Eric. We're wondering if you're saying that you personally would carry a court case forward to recommend it going to a judge regarding the mental illness exclusion before the 2-year review. That's
right.
Not what I heard, but someone's asking if that's what you said.
I'm happy to clarify that I am not going to lead the litigation charge in this matter. And I'll tell you why. Because I am a professor of law and a vice dean of law, and that's already too many jobs. So there are great litigators and advocates in this province. I'll certainly be available to chat with any of them who would like my advice, but it's not going to be me that brings a lawsuit.
Just before we go, I wanted to address there's some individual questions coming in through the chat. So if you do have individual questions about advanced directives, personal directives, advanced care planning, we're not able to answer those individually, but do feel free to email either the website I provided earlier, or Dine with Dignity Canada, 811. There's a lot of good resources out there, and we're happy to be that resource. It's just maybe not the best to answer it on this forum. Yeah. Thank you very much for joining us, Professor Adams. It has been very insightful, you're just so knowledgeable about this, the history of it all, and just have somebody who spoke at the Senate about this, providing this to us is a gift. Thank you so much.
Oh, well, I just, again, want to thank people for their time and also for, you know, their contributions to this, this public issue. It's not just, and can't be just decided by courts and lawyers. It can't be. It's got to be decided by all of us, and we all share in that responsibility. I know that this organization and the individuals who participate in it are really critical in that conversation. So my thanks to you and for the invitation to be here, and Chantelle and Basil in particular, who invited me and made this so smooth. Thanks to you both and Carl and others. Really appreciative.
Thanks again. Hopefully we'll talk again someday.
Yeah, appreciate it.
Take care.
Bye all.
Thank you all.